We continue our coverage this afternoon of former President Donald Trump's arraignment in federal court in South Florida.
Joining us now to talk about what this means for the former president's future is criminal defense attorney Paul Cambria. Paul, thank you so much for joining us.
My pleasure.
So this was Trump's first court appearance in the federal criminal case. If you can, let's just start this off. Break down the charges for us.
Well, there's a garden variety of charges here, everything from mishandling records to concealing records, tampering with witnesses, false statements. The highest offense carries 20 years, the lowest 5 years, and there's some for 10 years. But basically, when we read the indictment, it's a mishandling, a concealment, and then collaborating with other witnesses to do those things as well.
Paul, you have dedicated your life to this work. You've defended some of the nation's largest or world's perhaps largest defendants, and guys like Larry Flynt, who I'm thinking about. You and I have talked over the years about sort of legal philosophy. And in this instance, we have an indictment that I've heard you refer to these types of indictments as speaking indictments. They include a lot more detail than what you would explicitly get in a case like this on a normal circumstance. You have read indictments probably in the tens of thousands, if not more. I'm curious what your reaction was when you went through the 49 pages of great detail here.
Well, the things that stand out are text messages and recordings and apparently some statements by prior attorneys that Trump had. It's clear that some attorneys must have been witnesses here and indicated that they were asked to do things that were unlawful. But text messages, and there's surveillance, if you will. There's, security cameras all over Mar-a-Lago. Well, those security cameras show records and show movement of records and people accessing the records who didn't have authority to do so. There's a lot of incriminating evidence that is just there without any doubt about it being there.
The former president, of course, pleaded not guilty today in Miami. When looking at the defense, what can his attorneys do? What options do they have?
Well, I'm sure that one of the things they're going to do is indicate that, he had a right to have these records for some reason. Those rights appear to be extinguished at the time that he's no longer a president. There seem to be some rules that were put into place about people who are no longer in a particular position of security. So they're going to have to do that. There may be some movement of records that Trump claims he didn't know that people who had no authority accessed them and so on. But I think he's going to have a tough time with text messages and some of these other statements that people are going to make against him, which are set forth in this indictment. And, here it is, and it's very lengthy.
Paul, you mentioned the attorneys who could possibly be witnesses in this case, and we talk about the two attorneys who just resigned from his sort of staff of attorneys, if you will, who were set to essentially represent him in this case until they were not. We now know, with information that has come out since they have resigned, that at least one of them was asked, according to this indictment, by Donald Trump to either conceal or maybe just get rid of some kind of evidence. Now, we don't know about the truth of or the merits of that, but I'm curious if those attorneys, can they escape criminal prosecution by doing nothing, or would they have to work with the federal government in order to escape prosecution, considering they went to the feds to tell them what had happened?
Yeah, there's allegations in here, and they're identified as attorneys 1, 2, and 3. And it appears they say that attorney 1 was asked something like from Trump, well, can't we just get rid of the records? Or can we just give them part of the records? Attorney 3 supposedly certified that these were all the records when that person did not have that knowledge that they were all the records. It appears, however, since none of them are co-defendants, that, they've made certain agreements with the government in exchange for testimony. And there isn't any lawyer-client privilege if you're advancing a crime. The crime fraud exception trumps the lawyer-client privilege. So it's clear lawyers are cooperating, and they're going to say they were asked to do things that were unlawful.
Now, when looking at the timeline of these events of this case, what happens next?
Well, next is the discovery phase, if you will. The statutes require a number of documents, recordings, and other things to be turned over to the defense. Then the defense has the opportunity to make motions. Maybe they say that there should be dismissal of certain charges and why, or they ask for certain things that they claim have not been supplied. Once that's over with and the pretrial stage is over with, then a trial will be scheduled. And in the federal court system, they usually happen fairly quickly, although in that jurisdiction in Florida, there's a lot of activity there. There's a lot of offshore stuff, drugs, and all kinds of things that, I practiced in those courts, and they're very, very busy. So maybe next year we'd see a trial.
I'm curious, Paul, with your experience both in South Florida and elsewhere, the federal court system is very, very rigid. There are certain rules. You can't take your cell phone in if you're a member of the public, so on and so forth. All of those things, we all knew that's how it was going to be, although for some reason some people were surprised. I'm curious if you think this judge, or really any federal judge, will legitimately take the calendar, if you will, for former President Trump's candidacy, the rest of his time. Does that get taken into consideration when you're talking about a federal court schedule, or is all of that does not mean anything?
Well, there's an allegation here that this judge was in some way appointed by him. So that'll be interesting to see how that's handled, if there's some motion on the part of the government to disqualify the judge. But for the most part, they have a docket. They have people in custody, and the custody cases usually go first. And I don't think they're going to just artificially, rush this through. However it fits into the schedule, my guess would be that's how it'll happen, even though he's going to run for president. And remember, even if he were convicted of all of this and not in jail, he could still run for president. He's not disqualified because he's convicted of a felony. To be a president, you just have to be over 35, live here 14 years or more, and be born here. That's it. 3 requirements.
All right, criminal defense attorney Paul Cambria, that's all the time we have this afternoon. Thank you so much for sharing your insight with us.